Thank you very much. Good afternoon, colleagues, and welcome to this parallel session of the summit. I'm very pleased that I was asked to facilitate this session, and I look forward to listening to good input from our resource person as well as the participants. But before I kick off the discussion, I would request that all participants who are attending this session, that when they have questions or want to make comments, they use the chat box of the on the platform of this room, so that we can then look at them, note them, and then make sure that the respondents become aware of what the questions are, what they have to respond to. That's the main request. We won't be accepting any oral questions or clarification. So the people in this session, the first one will be our resource person, Judge President Dennis Davis, who needs no introduction, and I'm thrilled that he's our resource person. I read the summary of the document he's going to be framing the issues on today. I received it last night. Thank you very much for that, Dennis, and I look forward to hearing you going forward. Then we have Professor Theo Brodrake. He's the respondent that was recorded on the agenda, and he's well and ready. I think he joined before all of us, and that tells me he's raring to go. And then we have Mary Nell, who seems to have been disconnected slightly. Mary Nell is our rapporteur of this session, and she'll be assisting me facilitate this session. I know that the program referred to Ms. Tracy Lomax as the second respondent in this session. She sent an email last night that she has become involved in an urgent application for one of her important clients and may not make it. She suggested that if she's not able to make it, she'll send her colleague, Ms. Jonker, I think, if I'm not mistaken. But I've not seen Jonker join the call. So I would think then that if there's no second respondent, Professor Brodrake, you have more than your allocated time to respond. And I'm thrilled because you are part of the Stellenbosch family, and you'll be giving us and unpacking a lot more insights into this. All I want to say before I give the resource person to start talking to us is the overarching theme of this summit today cannot be contradicted with anything else, especially at this time of South Africa, where a lot of disparities have come to the fore. And I looked at the framing of the issues for this summit, and I was thrilled that it hits the nail on the head, and it locates access to justice as a critical point in all the discussions, critical goal 2 in terms of all the 17 SDG goals, because it is specific in its objective that within 15 years from 2015 to 2030, all nations or states should work towards eradicating injustice and inequality. And that's stated squarely in the Access to Justice goal in Goal 16.3. So that being the case, Dennis, I would like to give you the floor, Dennis Davis, to take your time and unpack the issues for our discussions today, and for Professor Brodrake to come on after you. So, JP Dennis Davis, the floor is yours.
Thank you. Judge President Malambo. Let me make 2 introductory remarks, if I may. One is that it is always an honor and a pleasure to share a platform with you, and I really mean that with all the seriousness that I can command. I think you know that, but I want to share that with others. And in fact, in this particular case, it's more appropriate because one of the issues I wanted to raise with regard to legal aid, and we are privileged, I should tell my colleagues, that we have South Africa's walking expert on legal aid sharing our session. So do you think you're only going to chair this session, my dear man? Think again, because you know more about this than certainly anybody, and I am fascinated in your views. The second, my second introductory remark was, as the day began, I wondered whether I could get through this, given what was going on in America, but it may well still happen that Biden may snatch a victory. So we're looking a little happier than we were at 7 this morning. I put a little document out because I was asked to try to frame some issues. It's a head of a large topic, and it's a topic that I was grappling with in relation to how best to do it. So I'm going to just very briefly, in a couple of minutes, just say why I chose these. But Professor Broodryk, feel free to tell me that there are 101 other issues that I've forgotten about, which deserve greater import than the ones I've put out. The reason I chose these were these. When I look, for example, at access to justice, and by that I mean access to the legal rights which people should have, whether they be accused in criminal trials or in civil cases, all too often they do not get adequate legal representation. We do have a legal aid system, and as I indicated earlier, Judge President Malambo has done heroic work in this regard, and it really does raise really profound questions about whether that is the system that we can continue to expand. And I raise this particularly as a result of COVID-19 and the fact that to some considerable extent, there's now a limitation on state resources of a particular kind, which may mean that we have to think somewhat more imaginatively as to how we're going to do the business of representation. But I do think it's an important point to bear in mind. And on my 22 odd years on the bench, it has troubled me on numerous occasions when one reads the situation of the case before you, how many times when you are faced with a default judgment and somebody's house is about to be taken away from them, notwithstanding the fact that the rules now seek to protect people in a way that they didn't before, how much would it have been better if they'd had access to a lawyer? And I was struck early on that at the Cape High Court, where I was the bar at one stage, was running a trial run whereby a judge who felt that a matter should be postponed so that the person can get proper legal advice could do so and refer this to a committee at the bar. The fact that that stopped saddened me, and I want to raise that and the methodologies related there too. So that's number one. I am concerned about the rules of court. They're complicated. They come from England. Yes, they've changed. In some cases, I battle to understand them myself, and I wonder whether they actually we can really seriously argue that they provide the most expeditious access to justice for ordinary people. You know, I mentioned default judgments. There are now a series of changes to default and summary judgment applications, which are not easy for even judges to understand. The question therefore arises as to how best we can actually provide a system which is truly understandable to ordinary people in ways in which their rights are actually affected thereby. And it's a really important point. You know, we are an African society, and so much we talk about transformation. And there are, I mean, clear anthropological studies which show manners in which certain forms of justice were essentially pursued in the past. And one might want to think about how can one incorporate the spirit of those into a system for many, many cases that actually would be more congruent with our mores. So I raise that as a second point. I'm particularly interested in this issue of mediation, which we've begun. in South Africa. I think we need to explore it and debate it more fully. There are many cases which clog up courts which do not need judges. There are many cases which are polycentric in nature, by which I mean, do we really have, is it really through the law that these matters are best dealt with? I'm always struck by the fact that when I'm involved in family law disputes, and I say to the parties, you know, what do I know about a family more than my own family? And there are no law reports in so many cases that are going to help me. And lawyers, in a sense, put more fuel on the fire. One really hopes that the mediation system that we've begun in South Africa can be extended, expanded, and dealt with accordingly. And I wanted to put that on the agenda for debate in relation to access to justice. I also wanted to say something about judgments. I often wonder who they're written for. And I often wonder, you know, that all very learned judgments, and I accuse myself of that too, let me assure you, of, you know, they're wonderful, and perhaps academics think they, you know, you're very learned and so on and so forth. But we actually must think about it. We also write for affected parties. We write for parties who come to court very often saving their last little bits of money in order to seek justice. And we don't lose. They need to know in their own way, in a way that is understandable and accessible to them, how that should happen. And that then links to a point I didn't make, but I just want to touch on, which is, are we satisfied that we are providing sufficient education to the public at large to ensure, one, that they understand how they can access justice through the mechanisms I'm talking about? And you see, I've tried to broaden it beyond courts. And are we satisfied that they know what their rights are? Ask any American child and they will tell you that they know what the rights of the American Bill of Rights. I'm not sure that's true in South Africa. And I don't think we've done enough to educate our public in this regard. And that then brings me to my last point, which I think is equally important. And that is the point that you've got a whole bunch of rights in the Constitution. A whole lot of rights which essentially, whether they're socioeconomic of nature, whether they are first generation rights, and if you do not have the benefit of, let's say, an NGO that comes to your aid, or you're lucky enough to get an amicus acting on your behalf, question is, are we satisfied that for the vast majority of people who live in homeless conditions, people who live on the margins, people in a sense who are denied fundamental levels of social justice, a society in which race and class are so inexorably intertwined that we cannot unpack the one with the other, in circumstances where for very many millions of people, the rights which are enshrined in that Constitution and which proclaim loudly, luminously, and eloquently you have these rights, how do you vindicate them? How do you, in fact, actually access them if you have no resources to do so, and you may not even know what rights you have? And I do think we need to have a debate about that. And so, Judge President, those were really why I chose those topics, but I would not be surprised if there's another list of many others of equally compelling nature.
Thank you very much, Judge President Davis. You've framed the issues very well, squarely, especially in this country within our constitutional framework. You mentioned the Bill of Rights and the myriad of rights that ordinary South Africans are entitled to, but do not have access to. You've pinned your talk largely on access to a lawyer and access to court and access to court resolution of legal disputes. I can say a lot more about it, and thanks for your comments about legal aid. I hope we will have time to discuss it, because I can tell you now that on the demand side of legal services, we are way out. We require a lot more. But let me not take the stage. Professor Broadrake, the stage is yours to respond to what Judge President Dennis Davis has said. Please go ahead, sir.
Thank you for the introduction, Judge President Lambo, and for the summary and context which you have provided, Judge Davis. I thought it quite succinctly and accurately captured the key issues and concerns which I think are relevant to a discussion such as this, i.e. one surrounding the rule of law and access to justice. Perhaps from the outset I can make an admission, and I admit that I'm concerned about the long-term implications of COVID. I think they will be profound. If you for a moment imagine the concentric ripples generated by a stone thrown into a pond, the innermost circle is the immediate impact of the virus: fear, illness, death. The second larger circle describes COVID's indirect health effects. So, for example, missed cancer screenings. The third circle, the social and economic impact of rising joblessness and shrinking economies, is larger still. And like every crisis, the pandemic will amplify existing social fractures and inequalities, and this will have political consequences. In fact, you could go so far to say that some governments may even fall because of COVID. That leads to the fourth and perhaps the biggest circle, that being geopolitics. How world powers choose to look after themselves versus the rest of the world may define global politics over the coming decades. These longer-term effects of COVID can, to varying degrees, I think, be avoided or mitigated. For example, regarding the social and political impacts of the third circle to which I referred, various interventions I think could mitigate the effect of COVID-19, such as debt relief, investment to help the digital transition, and enhanced democratic structures and institutions. And I think all these interventions are relevant to a discussion of this nature. As I've said, Judge Davis has, in my view, framed the key issues quite succinctly and accurately. I will now raise a response to a few of these issues addressed by Judge Davis, but I'm sure that the remaining issues will be covered in the discussion that follows. Firstly, I agree that more can be done through the present legal aid system to ensure adequate representation for the poor, vulnerable, and marginalized citizens of South Africa. Liz Curran and Mary Ann Noon, in the Journal of Law and Social Policy, state that if people cannot access legal help and assistance to seek remedies or enforce their rights, then their participation in society is diminished and the rule of law is undermined. The rule of law connotes equal treatment, equal legal protection, and accessible justice for every citizen. It's become an integral element of good governance in every democratic state. So in my view, the government certainly has a key role to play in ensuring equal treatment, equal protection, and accessible justice. And I think there's various ways that this can be achieved. An obvious way, myself coming from a legal aid background and context, is for the government to provide increased funding to increase the capacity of legal aid institutions to meet the demands of ordinary citizens insofar as the provision of free legal aid is concerned. Regarding Judge Davis's reference to the increased use of mediation, I'm afraid that my view tends to be a rather unpopular one. 40 years ago, in the context of a world survey on access to justice, Cappelletti and Garth sounded the following warning. They said that, and I quote, "The greatest danger is the risk that streamlined, efficient procedures will abandon the fundamental guarantees of civil procedure, essentially those of an impartial adjudicator and of the party's right to be heard." In my view, this warning has a special relevance in modern day common law systems with ever increasing demand for cheaper, more efficient, and speedier procedures for the resolution of civil disputes. For example, if a judge in the exercise of his or her case management powers strongly advises the parties to pursue mediation and stays the proceedings pending the outcome of this process, or directs the parties to proceed to mediation, the practical effect of such an intervention by the judge is arguably to deny the parties their right of access to court to obtain a judicial determination on the merits of the case. So although mediation, in my view, certainly has a role to play, I would caution that an overly strict exercise of case management powers by judges and an embracing of alternative dispute resolution methods such as mediation at the cost of trial adjudication may have an adverse effect on civil litigants' fundamental rights, specifically the right to be heard and the right of access to courts. Finally, I would also like to raise an issue regarding the question posed by Judge Davis, whether ordinary citizens can vindicate their rights and hold government accountable to its obligations as contained in the Constitution and then specifically in the Bill of Rights. In my view, the civil procedural mechanisms that allow for collective redress in South Africa remain underutilized. For example, in my empirical research, I demonstrate that since the introduction of the class action mechanism more than 25 years ago in South Africa, there have been less than 20 class action certification judgments handed down by our superior courts. The ability of such a mechanism to facilitate the provision of access to justice cannot be overstated. In fact, I call for the increased utilization of our collective redress mechanisms, even more so given the current socio-economic climate. Thank you.
Right. Thank you very much, Professor Broderick, for that response. And I've seen 1, 2, 3 responses so far. But I think just to kickstart the discussion and include the participants to this session, I want to deal first with the issue around mediation. I've heard your views, Professor Broderick, that you say we need to be cautious in how we use mediation and ensure that it doesn't deprive people of court judgments or court rulings to resolve their disputes. But there's a question that I've posed to everyone, and perhaps you may want to respond to it in the chat group, where I say I would be interested in the views of participants about having mandatory mediation in RAF cases as an enhancer to access to justice for road accident victims. There's a background to this. If you look at all court roles, in particular the court roles in Gauteng, you find that on a daily basis, more than 100 RAF cases are on the roll, and they all end up on the settlement roll, being settled. And the question you ask is, you look at the time these cases have spent meandering through the justice system until they are settled, it's nothing less than 3 years. Why should road accident fund victims have to wait for 3 years on matters that can be efficiently resolved through mediation? I think that's one question I want to pose for you. Do you want to respond to it now? Because that's just one class of the matters that are clogging court rolls, right? Where people are insisting on saying access to justice. But is it really access to justice when you require judges to rubber stamp settlement agreements instead of really adjudicating those disputes? So, Professor Broderick, I thought let me just raise that with you in view of your stance against mediation. Please go ahead.
Yes, thank you, Judge President Lambu. My stance is not against mediation generally. It's against mediation at the cost of civil litigants' right to access the court in certain circumstances. I do think that mediation has proven to be successful in certain spheres of substantive law. I think the Commission for Conciliation, Mediation and Arbitration is a perfect example of mediation, or in that context, conciliation, serving a very valid purpose and fulfilling a very effective role. I think the last time I saw, more than 70% of matters at the CCMA are conciliated. Nevertheless, litigants are in certain circumstances still afforded the right to approach the court should they so wish.
Yeah.
You validly mentioned that where it's simply a rubber stamp exercise, I agree that surely in those circumstances, the role of mediation could be argued to be more prudent or worthwhile to explore, as opposed to forcing litigants to engage in litigation in relation to those issues. We should also be careful not to create solutions or not to address the problems, which is the inefficient operation of the RAF system, generally speaking, not addressing those problems and rather trying to create alternative solutions where we should actually be addressing the problems that are vested in the RAF system at the moment. Yes. So just briefly, that's my view.
Thank you very much for that response. Before I move on to the other comments, JP Davis, do you have a view on the mediation part?
Let me just see if I'm. Yes, I do, very much so. Firstly, I agree with you, Judge President. The RAF is a bane around the neck of courts, and I'm absolutely convinced that in many of these cases they can be mediated. Family law, unquestionably, and it's all very well. I know what the research said in the 1970s. But I had a very valuable experience in Australia last year when I went and actually went to their courts and watched how mediation worked amongst the judge, with a mediator who was referred by the judge in a whole range of cases. And it's extraordinary the extent to which the sort of statistics that are being bandied around about the CCMA get effectively applied there as well. So you really clear out a whole bunch. And then you get the sort of cases which you and I would be well aware of, the sort of case where you're saying, can't you go and settle this?
Yes.
And of course, it happens every day. A judge is going to say that to the parties. And the answer is, somebody comes back and says no. And if you can say, I'm sorry, you're not going to go to a skilled mediator. You can't waste my time and the time of the court. A whole range of issues are going to essentially be parked, which essentially unlocks access to justice for others. And I think we shouldn't. I think we should hold on to it. It's certainly begun to work enormously well in the labour field, and there should be no reason why it can't in other fields.
Thank you very much, JP Davis. We can say a lot more because road accident fund victims are a class of people who require access to justice. And you can have a system, as Professor Broderick points out, of a system that enables and enriches lawyers at the expense of road accident fund victims simply because they can use court rolls to achieve that. But anyway, let me park it there. We've said more than enough.
It is a racket, you're right.
The next, thanks JP Davis. The next question, and I think it's a comment by Ms. Mbalem Jali, who makes a very valid comment that South African education on the Constitution and in general on the Bill of Rights is wholly deficient for the underprivileged, and many do not know how to access justice. University law clinics are vital in primary access to law and justice. I don't know if there's any comment that one wants to make. I can vouch for this, Ms. Mjali, that South African society in general does not know or understand the Constitution. And it's something that I think should be taken up in greater efforts to make sure that larger South African society is aware of what their constitution says about them, what they can access, what is due to them. So I think this is a very valid comment that I want to throw out there to both JP Davis and Professor Broderick, if you've got any things you want to say to it.
Professor Broderick may want to speak first since I spoke last, and I will come in after you.
Thank you very much. Prof. Broderick?
No, I think it's an extremely valid comment. I think a large part of what we as a university law clinic do is empowerment. Empowerment in the sense of educating communities on their constitutional rights, and educating them on non-constitutional rights, rights contained in the Consumer Protection Act, for example, financial literacy, upliftment and empowerment. So it's an important comment that she makes. I also think that Judge Davis raised an issue which I agree with. I think the way judgments are being written are, to a large extent, it's rendered inaccessible to the public at large. And I think one can link this comment to that specific issue raised by Judge Davis. This is also where law clinics come in. They have a responsibility to convey and communicate the contents of those judgments, which we do, in palatable and understandable ways. Let's take, for example, the Constitutional Court litigation regarding the lack of oversight, judicial oversight, in the issuing of emolument attachment orders in 2016. A large part of our upliftment and empowerment work is based on explaining the contents of the Western Cape High Court and Constitutional Court judgments to communities, not only within the Cape Winelands area, but nationally. Why? Because we don't think the contents of the judgments are accessible to the public at large, those people who are actually affected by the outcome of the litigation.
Thank you very much.
I couldn't agree with you more. Oopsie, I'm fine, yeah. I couldn't agree with you more, Theo. I think, if I had my way, we could do a whole lot of things. Let me give you an example. I think what the legal aid clinics do is fantastic. One can really broaden the horizon. There'd be no reason why we can't have on various radio stations, in vernacular languages, I should tell you, an hour every week. I sadly, because of my apartheid education, I can't speak in a vernacular language, but if I could, I assure you, I'd be more than happy to be on one of them, but I can certainly be on some of the other stations as other people could be. And you literally have a week where, if you take what Professor Brudraker said, you take that judgment, and in words of one syllable, you actually, the judgment of a week, which we can't court, or the Gauteng High Court comes down with a judgment. I mean, I think, for example, of Judge Potterell's very interesting judgment about children and food, the child health scheme, food scheme. Now, it'd be fantastic to be able to have had that on all sorts of radio stations where somebody comes along, explains it, and invites comment, and people listen to radio who are ordinary people, then get a real sense of what is going on. We can use television and radio and all sorts of media to basically explain in words of one syllable what it is that judgments are and why, and what implications they have for them. And one could expand that into trying to then explain to them, if people came along and said, well, we've got a school in the Eastern Cape that isn't getting food for its children, one would be able to say, well, perhaps you want to go to one of these particular NGOs and they may be able to assist you, etc. So one could really have a massive campaign. And I think all of the radio stations and television stations owe it to the country to provide an hour for free every week for that particular, just to give an example.
That's very critical, what you've just said, because I was minded to say the same thing about the use of radio stations, because you will be amazed. I mean, some of us who've done public interest law work, having gone to hostels, to taxi ranks, to informal settlements, as they are called, you find that in each household you'll find a radio. And they listen, and they listen, and it would provide and enhance constitutional education so much to make sure that if we have a public broadcaster that is properly aligned to what it must do within South African society, it would be easy to do what you what you say, JP Davis. And I think it's something that needs to be taken up and probably said in much more vocal terms elsewhere, because what the law clinics do, Professor Broderick, I think you mentioned that, the legal empowerment part, the reach in terms of what the legal aid clinics do, law clinics do, universities, court annexed or court based, is they reach the people who actually are in trouble with the law or require legal solutions to their issues. You need to reach that group and even a wider group that becomes aware of what is on the offing in terms of our constitution. So thank you very much for that. The next comment from Ms. Mchali is that, and it's directed at you, Prof. Broderick. It says, do you agree that access to justice requires the use of differentiated responses, and in respect of social justice, in respect of historically disadvantaged groups such as women, rural communities, and historically discriminated social classes? You've started to touch on this, Prof. Broderick, when you spoke about community empowerment legal programs. But here is a question that requires you to unpack even in a bigger context. And if you don't mind, you could also go to the traditional courts bill, in terms of what it's intended to do, in terms of these communities that are mentioned in Ms. Mchali's question. Go ahead, please, sir.
Yes, I think, again, a very good question that was posed. The short answer is yes, it absolutely requires differentiated approaches. I can give you an example, perhaps after I've sketched the context of the nature of the work that our clinic specifically does. We do civil work. We don't do criminal work. As part of the civil work that we as a law clinic do, we focus largely on the opposition of eviction applications instituted to evict farm workers within the Cape Winelands area. And secondly, we focus on family law related disputes. A large part of that work is the protection of rights of children and of women. And so that requires a differentiated approach compared to the work that we do, for example, in our Worcester satellite office, where the nature of the work that we primarily do there is the opposition of eviction applications. So last year, for example, we know that our customer base that comprises firstly mostly women, approximately 60% of the 2,100 individuals that approached us during the course of last year were females. And the majority of those individuals approached us with family-related issues. And so we know that it's important for them to feel comfortable in the way that we empower them and we enable them to look after themselves and their children. So in response to that, we ventured into the Somerset West informal settlement community last year to conduct a women empowerment workshop over the course of a weekend. We got the community's women involved in the workshop. We sat them down and we tried to, as far as possible, the entire clinic team was present, empower them, engage them in discussion, empower them, provide them with a toolkit to equip themselves, to protect themselves and their dependents. Our approach is quite different if you compare that to the impact litigation work that we do. For example, we recently litigated in the Western Cape High Court the Induplum judgment, which stands to benefit the South African community at large. Part of the beneficiaries of that litigation will not be necessarily be historically disadvantaged groups such as women. We anticipate there that the larger group of beneficiaries will be male beneficiaries. A large part of that group will be white male beneficiaries, although it will certainly benefit black and colored individuals as well. I think the point I'm trying to make is that you certainly have to adopt a different approach dependent on whom it is that you're trying to benefit and in respect of what the issue is that you're trying to benefit that individual. So our empowerment approaches requires a differential approach. I don't know whether that answers the question.
I think it does. You agree essentially that a differentiated approach is important and must be looked at, must be considered in the overall strategy of enhancing access to justice overall. So thank you very much for that. I just want to touch on an issue that you mentioned earlier about the funding of Legal Aid South Africa. I mean, those of you who look at what Legal Aid South Africa does and their annual reports, you'll see that about 70, just over 70% of their work is in the criminal law sphere, and less than 30% is in the civil legal aid sphere. Now, you ask yourself the question why the funding for civil legal aid services shouldn't be increased. Because if you want South African society to have confidence in the justice institutions it creates, it shouldn't, you don't expect South African society to have confidence if they say, well, you pump money into an entity that only focuses on people who are in conflict with the law. If you look at a number of studies that have been done, and I'm sure Professor Broderick, you are aware of this, they will tell you that there's a bigger need for legal aid services than for criminal legal aid services. But we still have this historical imbalance in the funding of the services that Legal Aid South Africa provides. Perhaps an answer lies in actually having a different entity that focuses only on civil legal aid offering. Because these groups that Ms. Mtshali mentioned, disadvantaged groups, women, rural communities, and historically discriminated social classes, Legal Aid South Africa goes out of its way to identify these marginalized groups and prioritizes them in the funds that it has in terms of the offering that it gives. But its funding is wholly skewed in favor of criminal legal aid services. So yes, JP Davis, you're correct. I was at Legal Aid and we made these representations at many stages, especially when we went to the portfolio committee, right? Because in each sector of society, you'll find that there's a group that requires prioritized legal assistance, in particular, distressed bondholders. It's an example. Women, rural communities, in terms of their access to the services that they are entitled to, right? That are all available in the urban areas, and they've got to spend money to travel to the urban areas to access those things. So I think this is an area that requires proper attention in terms of ensuring that there's proper funding, not only of Legal Aid South Africa, because by itself, it will not be able to take care of the demand side of legal services in South Africa. To also make sure that, as the call was made this morning by Prof. Madonsela, that corporate South Africa needs also to look at the legal NGOs that are there, that are properly located in terms of advancing particular needs of South African society. I think let me just stop there and hear if there's any comment to that, seeing that I don't have any other questions coming up. Prof. Broderick, maybe on the funding of Legal Aid South Africa?
Yes, so at the moment, firstly, I agree completely. I think at the moment, Legal Aid South Africa provides the opportunity for university law clinics to apply or to tender for service delivery as a cooperation partner.
Yeah.
And that's within specifically the civil space as opposed to the criminal space.
Yeah.
I think what's of particular concern is the decrease in funding allocation by Legal Aid South Africa to the law clinics to provide those civil services. So the pot of gold is getting smaller. The number of competitors are increasing because the demand for the service is increasing, understandably, as you pointed out at the commencement of the session. The state of or the extent of need for access to civil legal aid services it hasn't been as high as it is at this point in time. The question is, again, as you correctly point out, how do you address that need? Ideally, there would be an increased funding allocation by Legal Aid South Africa to not only law clinics, but legal aid providers nationally to assist it in providing civil services. Secondly, it shouldn't be lost on us as university law clinics that we have an opportunity to empower community members, community leaders, to empower their communities, ideally through paralegals at legal aid institutions, formal or informal, in those communities, to empower them to advocate on behalf of those communities. I think that's something that we as legal aid institutions need to explore so that we don't sit back and we wait for the state to increase its funding allocation to Legal Aid South Africa and then for that to dribble down to legal aid institutions. I think that's one practical example of what could be done over the shorter term to address the need.
Yeah. No, thank you. Thank you very much for that. JP Davis, any views from you on this aspect?
Well, I think, I think you're right. It is an anomaly. And my fear, of course, is we aren't going to get any money because there isn't any money to be had. And that's a real problem. So the question is, how are you going to do this? If we are, we've seen the justice budget already being cut this year. I think that's really wrong in all sorts of ways, and we probably need to deal with it. But I'm really anxious about the fact that with an impoverished resources, the idea of expanding into the civil area then becomes a serious problem. And you're dead right. There's an anomaly here which we need to fix, but it ain't being fixed. Now, I do think that in the interim, the bars, the legal profession, should be helping the legal aid clinics as best they can. Won't be perfect, but at least make there was no question. I noticed when they had the pilot scheme in the Western Cape High Court, it helped a hell of a lot of people, which sadly now don't have any assistance at all. But I'm really anxious, JP Malambo, that where are we going to get the money from?
Yeah. Perhaps it's a proper consultation process by government is necessary here. We have the government establishing the Solidarity Fund to assist because of the COVID-19 pandemic, which is commendable, right? I don't want to talk about what's happened to the money that was meant to go there, but I'm just saying that's a noble decision by our government to establish a fund that looks at people who have come out croppers because of the COVID-19 pandemic. But if you're going to disable one of the key constitutional entities that must enhance and enable access to justice by reducing their budget, you disable them by, if you reduce their funding, they will be forced to reduce their legal capacity in terms of warm bodies that attend to these matters, either in terms of lawyers or in terms of paralegals. They've got to close offices. Now, if you create a solidarity fund on one side, but you disable an entity that will ensure that beneficiaries who must get assistance from the Solidarity Fund, especially those in rural areas, is disabled in terms of doing that, I'm not sure if we're going anywhere. So we need a much more bolder approach to this. I mean, one aspect that I'm not scared to mention is you can't just cut the budget of an entity like Legal Aid South Africa, because it's a key entity that's there to ensure that there's access to justice overall. If you disable them, you're actually creating an avenue for people to start not having confidence in our rule of law or constitutional arrangements. I think that's one issue, the issue that I thought, let me just mention. And linked to this budget issue, Ann Smith has posted a comment here that says, indeed, the education budget is also being reduced. We will need to think very creatively. Our law clinics will in future also involve many more final year students than what was the case up to now. So this still addresses the budget. I mean, properly stated, our government needs to prioritize entities that are ensuring constitutional confidence than throwing money at entities that fail to live up to their objectives year in, year out. Right? I'm sorry I have to mention this because we see it, we preside over cases that show us where the money is going, where it should not be going. JP Davis, I see you've come up.
I cannot but agree with you. And in fact, one of my favorite, I wanted to say amen to everything you've said, but I want to go further, if I may, and it's simply to say this. When you say, well, not further, but just to amplify the point, when you say, government has got to basically spend the money on areas that ultimately vindicate their constitutional obligations, dead right. The way a budget should work is you start off by actually saying, we are obligated to provide basic housing, education, medical care, etc., for society. Those are constitutional commitments. When you fashion a budget, you fashion around those priorities. And you don't fashion around sort of, if I could call it, all sorts of fancy projects that actually are not part of that, vanity projects. So you're right. And one of those commitments has to be the vindication of access to justice. It's that housing, education, water, etc., etc. All of those are vital. And you're right. We have to frame the debate, and that I think is what we should also be doing, all of us, saying when the budgets are formulated, you are constitutionally obliged to ensure as best you can to progressively realize those rights. What that therefore means is that when you actually sit down and plan your budget, plan it in a way in which we can see a progressive realization of those rights. I don't see budgets being fashioned that way. Otherwise, I don't quite know how you give 10.5 billion here and 15 billion there. And as you rightly say, we often see those as judges. So your point is a profoundly important one, in a sense, integrating, in a sense, this stream with other streams in precisely ensuring that our priorities are essentially based on our constitutional commitments.
Right. Thank you very much. I've just been told that we've got 5 minutes to wrap up this discussion. Thanks for that, JP Davis. But just to go there, I see there's a question here from, is it Claudia Milovich from Business Day, who says, does that mean that the budget should then be allocated to the NPA or legal aid instead of, for instance, going to SAA? My own... I'm not going to answer the question. All I was saying was there needs to be proper consultation, proper identification of really needy aspects of our society or of our government activities that identify areas where you can just willy-nilly cut their budget. And we know that our government focuses on the economic cluster in terms of bailouts, right? And that's where I come in when I say you can't relegate access to justice entities that ensure that constitutional confidence and confidence to the rule of law that you need, right? And these are entities that have demonstrated year in, year out that they have very little or no corruption in their ranks in terms of misusing the monies that are allocated to them. And they show you, especially Legal Aid South Africa, that their spending of the budget that comes to them is up to 98%, 97% every year. So why then do you go there and cut when you know what the critical role they are playing? So I'm not going to answer that question for yourself, for you, Claudie, but I'm sure you can read between the lines what we are saying. We've got 3 minutes to wrap up.
I just want to add, can I just add to that? Claudie's point, it's a mischievous point, because you're right, we are not in a position to say whether money should go to SAA or to elsewhere. The fundamental proposition that I think we're advancing is that the government is obliged by the Constitution to vindicate those commitments which it has in the Constitution. And if you read, of course, it means safety and security of the people, which is where police come in, education, health, water, etc. And it also means access to justice, which is not a massive budget compared to the others. I mean, for a relatively small sum of money, we could do a hell of a lot. But all I'm simply saying is that we need to have a debate in which we can see how those prioritizations are justified. And that's the debate we should have. And that's why the access to justice issue becomes so important.
Thank you very much, JP Davis. Professor Broadrick, when you respond now, your closing remarks, I think you have less than 2 minutes to do that, is there's another comment, very valid comment by Ms. Mjali, that there needs to be a revision of the budget allocation if there's a disproportionate use of funds for criminal legal aid, but there is still a high capacity rate in our prisons, which are situated very far in many instances. Those who are underprivileged in the first instance will have limited access to their family support in the event of rehabilitation attempts, which may impact the recidivism rate. And she asked boldly, is this wrong? I think we've spoken about this today here, but maybe you can respond to this and also make your closing remarks if you want.
Well, I think it speaks exactly to the issue that's been raised now. It's a broader debate that needs to be had about funding allocations. Yeah. I want to revisit something that Judge Davis raised earlier that we didn't really elaborate on. I think we shouldn't lose sight of the fact that potentially there's scope for increased self-representation by individuals to approach the lower courts in South Africa had the rules been more user-friendly. I think that's something that can also assist in facilitating access to justice. At the moment, the rules are drafted in such a way that it's complex, it's difficult to navigate. In some instances, for attorneys and for counsel, how can you expect the indigent community to navigate those rules? If those rules are drafted in a user-friendly fashion, we don't need to sit back and wait for government to increase funding allocations. Those individuals can approach the court en masse, either small claims court or the magistrate's court, and vindicate their rights on their own accord to the extent that it's possible. And I think that's something that needs to be explored as well.
Thank you very much for that. I think because of time, I've got to bring this session to a close. Mary, I think you've got your work cut out in terms of producing the summary of this discussion for the final plenary report back. And let me take the opportunity to thank JP Davis, my friend, my partner in arms. Let me thank Professor Broadrick for your very worthwhile and valid
Thank you very much.
Comments that you've made today. Thank you very much to everyone else who's attended this session. Ms. Mjali, thank you very much for all your comments and questions. You've made this session a very lively one. Thank you very much then to everyone.
Pleasure. Thank you to you for chairing so much.
Thank you very much. Cheers.
Thank you. Thank you.